Lewis Wall.
Kia ora, te manga
Kia ora.
i te whare. Thank you very much for the opportunity to contribute in this first reading of the Children, Young Persons and Their Families, Advocacy, Workforce and Age Settings Amendment Bill 2016. I'm not a member of the Social Services Select Committee, but I am Labour's Youth Affairs spokesperson, so I take particular interest in this piece of legislation. And so I immediately want to focus on one of the main features of the bill, which is about extending the age of state care and protection to a young person's 18th birthday. Some of the questions that I have already, that it seems that increasing the age to 18, there's been a lot of discussion about what that age should be. Some people think it should be 21. Some people think it should be 25, and it's interesting to note that actually, and I found a piece of research which was associated or is associated with Action Station and their petition, which is currently wanting to increase the age to 21 years. But one of the key findings was that why 21? Because actually, when we look at young people today, on average, they stay at home until they're 23. So young people today actually need the continued support of their parents. And so one of the rationales from Action Station and their campaign partners, and I want to list them all, it's the Dingwall Trust, it's LifeWise, Youth Lines, the Child Poverty Action Group, the Wesley Community Action, the Christchurch Methodist Mission. They're currently engaging in a public process to say that the age should be 21. So I do want to say to the government, it's a step in the right direction, moving the age from up to their 18th birthday, which I guess technically is when a person stops being a child and becomes an adult. So I can kind of understand some of the rationale for that particular age. But actually, when we look at the specific cohort of young people, I think that we should seriously already start looking at that age, and from the perspective of a lot of organisations involved in the care and protection of our children, they think that that age should be 21. One of the other questions I have in relation to that first point is, why is it only children in care and protection? Why does that particular responsibility, statutory responsibility on the state, not extend to young people in the youth justice sector? And it's been really baffling to try and determine why the government has chosen to do this, because the bill states that its purpose is, and I quote, reforming the system of services for responding to the needs of vulnerable children and young persons. So what do you do when you get a purpose like that? Actually look at definitions. Well, I do. And the definition of vulnerable is people who are in need of special care, support or protection because of risk of abuse or neglect. So you kind of start working through a process about why the government would have excluded young people who are in our youth justice system when they're going to be providing for young people in our care and protection system. And then you actually look at the expert panel's Modernising Child, Youth and Family interim report, and their vision for New Zealand children is, and I want to quote, the panel's vision is that New Zealand values the well-being of our children above all else. And when they look at or state the role of the state in caring for children, the purpose of the care, protection and youth justice system is to ensure children and young people are in loving families and communities where they can be A, safe, B, become strong, and C, to flourish. And when you look at the principles that drove the government's expert panel, they said that the place of the child or young person had to be at the centre of everything that we do. So this piece of legislative reform is supposed to meet the needs of the most vulnerable young people who are in our SIF system. They're either in our care and protection system or they're encapsulated within our youth justice system. And so it's interesting or baffling as to why children in the youth justice sector are not included, and explicitly from this piece of legislation. And one can only assume that there is some political issue about including young people in the youth justice system, that possibly means that the government's going to be soft on crime. Who knows? But we're hoping that some of that motivation for excluding young people actually comes to the fore, and that we can actually understand what this government is trying to do. Because on the face of it, they're contradicting recommendations from the expert panel. And so for somebody who's incredibly interested in this piece of legislation, I will be trying to determine, like the rest of the country, why that's the case. The other 2 points that I want to make are around the government's rationale for the bill being to ensure the views of children and young people are taken into account as part of decision-making at an individual level and in the development of services and policies. And what I want to note is that actually in the 1989 SIFS Act, Section 21, it states that it must give effect to the wishes of the child's or young person's family and whānau. And so already ingrained in the current Act is a commitment to listening to children, ensuring that the voices of the whānau are incorporated in any care planning. So I find it, again, interesting that we've chosen to ensure the views of children and young people are taken into account, because they already should have been. And so the fact that they haven't been beggars the question about how the new processes, the new systems are going to ensure that not only the young person's voice is going to be heard and paramount, but also the communities. And those communities are actually the communities of interest associated with the child who is in care and protection, and I contend in youth justice facilities. And specifically, any formation of advocacy groups or any input has to, at the core of it, ensure Māori voices are front and centre. Because the appalling statistic that we all have to face is that 57% of the 3,844 children in care are tangata whenua. That's not a random phenomenon. It has happened because the system, over consecutive years, has failed to meet the needs of Māori. And the intergenerational transmission of children in care actually is something that we should all be we should be committed to addressing. And the only way we can address it is if we have Māori around the table, and many Māori, not one Māori. And in fact, if we look at the beginning of this process, there were no Māori. And so I question the integrity of this whole process, given Māori haven't had many more seats around the table trying to look at the system that has continued to create and generate a situation where Māori children have been encapsulated in our SIFS youth justice and care and protection system. I can't not mention the wonderful Judge Mick Brown in my contribution, because it was Judge Mick Brown, through his work as the first principal judge of our youth court, who actually brought in family group conferences. He ensured that whānau were intimately involved in trying to deal with youth offending. And as a second principle, they did make a concerted effort to not charge our youth offenders unless there was a public interest required. And so I think if you look at the legacy of Judge Mick Brown and what he tried to introduce, which was actually about recidivism, to stop it nip it at the bud, so that we could actually assist those whānau, to assist the young people and ensure that they got all the services that they required to address actually the context of some of the behaviour from our young people. And I think that's where we've failed, actually. We've failed to give our young people and our families the support that they need to provide them with different opportunities in life, different pathways, different visions, different, life outcomes. And so when we look at this piece of legislation, I will be scrutinising how involved Māori will be in this process, how involved our young people will be. Because if we end up, again, like last night, creating a prescriptive system that's going to tell our young people and families what to do, then we already know that that will fail. And I hope that on this side of the House we will think of some amendments to this particular piece of legislation that will make it work for all of our young people. Kia ora.
Maureen